Hello and welcome to Law and Democracy, a podcast of the election law program at The Ohio State University Moritz College of Law. I am Steve Huefner, the Deputy Director of the Election Law Project here. And today, I'm delighted to again be joined by two senior fellows of the election law program, Tony Gaughan, who is a law professor at the Drake University College of Law, and Terri Enns, who is law professor here at the Moritz College of Law. And today we have as a guest on our podcast, our OSU colleague, Dakota Rudesill, who is a special expert in the areas of national security law, but also with deep expertise in the political process and the congressional process and the way in which the federal government operates. And so we are especially pleased that we can have Professor Rudesill with us today. With that, I'll let Tony begin our conversation.
And Dakota, how would you characterize the historical moment that we are currently living in?
Well, I would frame it up this way. We have what I would characterize as a constitutional operating system, which is one of separated powers, of checks and balances, of federalism, basically distributed power. And being run on that operating system now is what I would describe as autocratic political software. There's, folks who are interested in this and, who haven't been reading it already can, read the really sizable developing literature comparing the approach that the second Trump administration has been taking to governance with the actions of other parties and leaders in a number of other countries who have undermined the norms of their countries or at least dramatically transformed them in ways which are much less resembling of, again, a political system with distributed power and lots of checks and balances. And what has happened over the centuries is that in terms of constitutional practice, what the Supreme Court often calls the gloss of history, that part of that has been professionalism, the work of different professional guilds or tribes, or terms I like to use in my scholarship on this, their work within the federal government and in civil society around the federal government that interacts with it. And that the work of those professions for a very, very long time now has really become integral to the functioning of that constitutional system, and in fact has reinforced and buttressed really, really important aspects of it in terms of checking bids for highly consolidated power, checking bids to do things which might undermine the rights of minority, which was a central concern of the framers and especially Madison in the Federalist Papers. So we've had that, again, the work of these professional tribes has become, I would say, part of the constitutional gloss and structure of our country. And the moment we're in right now is one of unprecedented pressure on professions, on a number of different ones we can talk about. And that is, again, part and parcel to, I think, what is very clearly an effort, whatever people have in terms of partisan preferences or policy preferences, higher taxes, lower taxes, whatever it is, it's without question, at least in my judgment, the most aggressive effort we've ever seen to consolidate power within not only one branch, but one person. And not surprisingly, in recent months, we've seen that effort run right up against the professional ethos of a number of different professions.
Can you give examples, Dakota, of the professional tribes that you have in mind?
Yeah, so I wrote an article a few years ago in the Hofstra Law Review in which I talked about three of them. But I think that these insights can really map more broadly than that onto other professions. So the three that I looked at were the professions of law, of arms, the military, and the profession of intelligence. And I focused on these because when I was in government, in all three branches of the federal government, I saw these professional tribes in action. And at various points, I was part of two of them. And it was a fascinating thing to see them doing their work kind of individually, if you will, within their profession, and then interacting with one another and doing so within branches of government, across branches of government, and then interacting with the politicos, the elected politicians and their politically appointed staff. And oftentimes those interactions worked really, really well. But other times there were tensions. And some of them I think were helpful tensions, and other times they were not very helpful tensions. But in any event, it's part of an overall system that I think has, you look over the course of the history of our country, obviously imperfect, lots of ways, ways in which things can be improved, but has often produced really, really good outcomes in terms of good process and quality decision making. I would just mention a few kind of common qualities of professions, and especially these three professions that I discussed. And I wanted to do this. I wanted to write this piece, and I've been talking about it and developing in other pieces since then, because I think that there's a sense commonly, and I think even within government sometimes, that these are just really, really different worlds, like law, military affairs, and intelligence. But I actually think that that's not true. So all professions have in common a number of things. So one of them is that they have specialized expertise. They know stuff in detail about a particular subject, right? They have, and to get that specialized expertise, they get specialized training. Here at a law school, right, we train lawyers, right? Same thing for the military and for the intelligence folks, they get specialized training. There's a licensing process which reviews people once they've gotten the training or while they're getting it for admission basically to the guild. And for the lawyer, that's the bar exam and the character and fitness review that goes along with that. For military officers, it's to be, and also for enlisted folks, right? It's to be entrusted with being part of the military service, right? And also it's a security clearance. I noted so clearly the similarities between these professions when I was doing an update to my security clearance. At one point at the same time, I was preparing my character and fitness application to be admitted to the bar. And they were more similar than they were different. It's the same stuff about your background and your reputation for being somebody who's trustworthy, your ability to follow rules, things of that nature. And then for the intelligence folks, there's kind of there's an ethos which goes with intelligence, but there again, security clearance. And so in all three of these cases, right? License to practice law, license to access the nation's secrets, license to use force legally, including lethal force, right? These come, that's kind of the certification and licensure process of this. And then that is something that you retain if you follow the ethos of your profession. And the ethos of that profession has a number of key things in common. One of them is that you have an obligation to exercise your independent judgment when it comes to doing your analytical work. That doesn't mean that you substitute your own policy preferences, right, for those of the people that you're working with. So, for example, the lawyer, should not tell their client, especially like their government client, you should work for higher taxes, right? Or you should reform the farm bill in these ways, right? I mean, the lawyer shouldn't be doing that unless they're in a policy position, but then they're not really practicing law, or that's separate in addition to practicing law. But where the independent analysis comes in is in connection with another key aspect of the professional ethos, which is what I describe as a heightened fidelity to the truth. You have an obligation to be very vigorous in your assessment of the facts, if you're a lawyer, the law, right? And to have integrity about the opinions that you offer on that matter. And for the lawyer, for example, one of the key judgments is whether an argument that you're putting together, a argued vision of the law, right? An argued interpretation of the law, right? Is that a reasonable interpretation, right? Or is that a frivolous legal argument, meaning a legal argument which you cannot find reasonable support for, right? So for example, I'll give you an example of that. So a frivolous legal argument would be something like, the Second Amendment, right, bars possession of firearms in America. Well, that's completely contrary to the Second Amendment. You can read the jurisprudence. Like, that is a frivolous argument, right? So as a lawyer, you couldn't make that type of argument. For an intelligence professional or a military professional in the military, especially when you get into the very senior ranks, they also, if their their policymaker boss were to say that military military commander or intelligence analyst, right? Your judgment is going to be that Uzbekistan has nuclear weapons, right? Well, if your assessment based on all the information is that you can't reasonably sustain that claim, you can't go along with that, because then you're lying, right? You're lying, and you're also sacrificing your professional independence. And in the law, we often call this clientitis. You've completely merged with your client, lost your professional independent judgment. And so those are some of the common things about professions, and they do some valuable work, such as operating as a check on error, in organizations, right? They operate as a check on abuse of authority, right? Again, imagine somebody who's, trying to do something which is plainly fraudulent, false, illegal, right? Having these professions operates as a check on this. The professions also tend to facilitate good process and deliberation, because again, their commitment to a elevated standard when it comes to the truth. So for all those reasons, I think that these professions are really important.
So those common characteristics seem to be quite important to me for a number of reasons. One is because of how it allows us to distinguish what these guilds or professional tribes are from another kind of perspective. And so I'm going to ask this as a provocative sort of question.
Yeah.
There's been increasing attention in recent years to the notion of a deep state, this notion that the levers of government are being controlled in some unaccountable and typically nefarious in the way in which the allegation of a deep state is leveled. And it seems to me that as we talk about things like these guilds or professional tribes, that if somebody were to just understand that at a superficial level, they could think of it as evidence that there is this deep state at work. That's exactly what I've been worried about, is that behind the scenes, there are these operations underway that are not called for by the law, but they're just this way this group of people has chosen to operate, and it's unaccountable. So I'm setting that up with an invitation for you to differentiate or distinguish the pejorative label, the deep state, from these guilds, these professions that share these common characteristics.
Yeah, I think it's a really urgent question. I think it's a timeless question, and an especially urgent question now, because we do have this allegation of the deep state. I would say that it's that one should be concerned about a couple things potentially, but then I'm going to massively caveat that. So one of the caveats is what we can call institutional parochialism. And that can happen within an institution of government, such as a particular federal agency, right? Or within a branch of government, executive versus congressional versus judicial. It can also happen within these professional tribes as well. And they get this idea that they are the most important entity. And they are, they look around at these wonderfully trained and expert colleagues that they have. And they think we know so much. They regard themselves as, as well-motivated public servants. And they feel like we have the best interest of things in mind. And if people would just listen to us, things would be fine. And out there is a them. And it's those people. And you can't trust the other people to have too much power. Because they're just going to muck things up. And I saw this over and over again when I was in government. And there's tension between these professional tribes where so often people, and I was lucky enough in my career to have a pretty extensive career before I became a lawyer. And I stood in policy shoes, congressional shoes, political shoes, and saw the worry that if you let the lawyers get a hold of something, right, they're not going to let you do anything. They're going to slow it down, bury it in process, bury it in meetings, right? And when you stand in these other shoes, it's very similar, right? Again, like, if you let the communications professionals get it, right? Everything's just spin and media and public relations and whatnot, right? It's the same thing. And you find it between institutions as well. And it's just that that's a natural thing that humans do. We tend towards groupthink. We tend towards having like there's a virtuous us and a bad them, right? And I think that that plays into this notion of the deep state, right? Because there's enough of a grain of truth to it that institutions and groups of humans get resistant to change, and they protect their equities, and that slows stuff down, and that's not great. And I think that's a completely legitimate thing to wonder about. And so I think that to check that, we need to recognize that some of the tensions between different professional tribes are good. And the tensions between different federal agencies are good. The tensions between the three branches of the federal government, between the federal government, the state government, this is good, right? The tension between government and the press, the journalistic professionals, right? This is good. And not understand it as these like apocalyptic battles for supremacy, right? Instead, it's like a favorable friction, right? And them interacting with each other is good. And you also need appropriate, review within institutions and professions themselves, I think, to make adjustments where necessary. So I think in that sense, there certainly is this tendency towards parochialism and kind of this paranoia that's the dark side of esprit de corps, insular thinking. So I think that is real. But what I think is not real is the claim that there is some broad-based conspiracy or federation of conspiracies, within government and civil society, right, to, lean in one sort of, political direction or another. I just don't think that that's accurate. And I think what proves that that's not accurate is abundant evidence that, for example, most people in the legal profession, definitely not all, but most, right, tend to lean in their politics left, right? And within the military, they tend to lean right, right? So, it's not like there's some sort of like broad-based, deep state conspiracy to, lean in one direction or another. Instead, what you have are institutions that are groups of humans, and they tend to have, rough preferences or whatever, with a lot of diversity within them. So I don't think that that's accurate. And I think I'll be very blunt too, and direct, the allegation about the deep state, comes from, Mr. Trump in particular, and a lot of people who support him. And I think that it's a lot of it has been really, really supercharged by the fact that his conduct and that of people around him ran him, in 2016, and then during his presidency, and now even more so, and after his first term, right up against the work that these do. I mean, there were abundant, as documented in the Mueller report, which didn't lead to DOJ charges because of DOJ policy about charging the sitting president. But if you read especially the first volume, just abundant evidence that people around him had extensive ties and links to Russian intelligence officers and people that I can't think of any sort of precedent for that, right? And this is what our government does, is recognize, Russia's been our number one espionage adversary. And then when you have lots of people who are connected with someone who's running for president, and they have extensive ties to people in that hostile intelligence apparatus, I think anybody would say, my goodness, as intelligence officers, or as lawyers who do counterintelligence work, like, we have to look into this. You just have to. And then, of course, Trump got, faced an array of criminal prosecutions at the state level, the federal level, an array of civil suits, and then there were an array of judgments against him. Right, he and his company were, faced judgments against them for fraud, and he was adjudged culpable for sexual abuse. He was criminally convicted in the state of New York for financial crimes. He was also charged, I think, very, very credibly in federal court for very extensive knowing, that's the key word, violations of the law about retention of classified information after he no longer had any legal authority to have. I mean, so things he did ran right up against these professional communities and just the work that they do as professionals. And so I think that supercharged it. And unfortunately, our politics has now gone in a direction where I think a lot of people who are very well-meaning and share certain policy preferences with Trump, right, have now bought into what I think is very personal grievance for him with communities of professionals who are just doing their jobs.
So it is quite interesting to think about the potential genesis of the deep state complaint as coming from your opening metaphor, right? That it's partly a result of trying to operate, how did you put it, like an autocratic piece of software on a democratic operating system. And that the friction around that has then produced a bunch of conflicts with existing dimensions of our operating system that then lend themselves to being labeled as deep state, because that's the only way to try to overcome the defect of running this autocratic software on a democratic platform.
Yeah, I think that's right. And I think it's, I'd say two things about that. One is I think it's unfortunate, again, from the standpoint of the country, and I think the standpoint of a lot of voters who I think are just very well intentioned in having, one or more policy preferences, right, which, cause them to, line up with him. Because I think that, if you look at a lot of the pieces of his agenda, from a policy standpoint, these can be accomplished without going to war with the institutions that sustain the rule of law. Removing from the country, a number of people who are, undocumented or otherwise have run afoul with our laws, right? I mean, we have established processes for these things. They, a lot of that can be done, or different trade policies, or, take your pick, right? Even replacing our current administrative state apparatus in the executive branch, right, with something which is dramatically different and dramatically smaller. Our legal system is fully capable of doing that, right? The extensive federal executive branch was built out through statutes that Congress has passed, right? And, and then thousands of other statutes, amending them, funding them, whatever, right? I mean, it's this really dense body of statutory law stretching back. Maybe you started with the civil service, or maybe you started with Hamilton's Treasury Department, wherever it is, right? Thousands of statutes, right, have built this out, right? And then there are regulations issued pursuant to those authorities, judicial interpretations which refine this system and resolve legal disputes. Congress's blue and red, president's blue and red, like our system built this thing. And the branches of government, and especially Congress, which has the lawmaking power under the Constitution, has all the legal authority it needs to eliminate most or all of it and dramatically change it, right? But what we're seeing instead is not using the constitutional operating system we have. And instead, what we have is, I think it's 130 executive orders now, from the president, plus the actions of the Doge group, to use the words that many folks in that circle have been using, just move fast and break things, right? Just do stuff. And they have run afoul of, facially, dozens, hundreds of statutes. And when you think about all the amendments to those statutes over the decades, thousands of statutes, right? Just run right roughshod over them. And that's why a lot of why we're in this moment, because, again, the operating system we have is not being used. And instead, it is a one person, right, issuing orders and having a group of people around him who are just trying to do stuff. And that, again, that's concentrated power, which the framers were very skeptical of. And factional behavior. Madison wrote in a number of the Federalist Papers, Hamilton too, about the danger of basically a zealous group of people, right, who have a particular vision, and if they get into a dominant position, tend to oppress the rights and preferences of others, right? That was the Madison and Hamiltonian observation, especially Madison, but Hamilton too. And so they built the system to blunt that. And so what does the system do? Well, it says, if you want to change law and policy, you use the mechanisms and you're willing to compromise, right? But if you say, I'm not willing to compromise, and you're going to try to be one person or one institution and dominate everything, well, that operating system is going to fight you, because it's intentionally designed not to allow that, because the framers were so fearful of a Caesar-like character, right? Loss of Republican government into autocracy, right? So I think we're seeing that tension play out. And I think the massive question for us right now, is, does that operating system hold, right? Or does it get dramatically changed, as we've seen in a number of other countries, into one where you read the documents and it looks like a distributed power system, but it isn't anymore, right? There's just one guy, something like that.
So Dakota, when we talk with our class, one other aspect about professionalism that we've talked about is the self-governance part. You know, the legal profession governs itself, the medical profession governs itself, etc. And yet you've just been eloquently describing the value of separation of powers and checks and balances. So how do those two things relate to each other? A tripartite system of checks and balances, and yet these three professions that you talked about, law, intelligence, and arms, military, if they are self-governing, is part of what we're seeing self-governing gone amok and we need to have checks and balances, or is it anyway? I'm just wondering about how those relate.
Yeah, absolutely. Well, so that's the the elections is the democracy piece of it. In a number of the Federalist Papers, Madison and Hamilton observed that we have basically a hybrid of what the ancients understood to be democracy and republican systems. Democracy meaning direct rule by the people. Think of ancient Athens, where all the voting citizens, the men of Athens, the free men of Athens, would get together in one amphitheater and they would vote directly on things. There's direct democracy. You could do that in a little city-state in, like 430 BC, right? And then you have republics, which is more like the ancient Roman Republic, with these institutions that separate and distribute power. For example, the ancient Romans had two chief executives, the consuls. They always had two. They never wanted one because they were worried about kings, which they never wanted to have. And your term was 1 year, and it could not be repeated. And as a further step on it, they required that after you served as consul, you had to leave town. You were sent out into the provinces to get you out of town, right? Again, so the republic distributes power, right? And you have, you have the people who are representative, right? Like the tribunes and the Roman Senate. So it's kind of, we have a hybrid of democracy and republican systems, and the idea, right, is that the preferences of the people are going to matter, right, in terms of the policies that the government enacts. And it's easy to understand, you vote for somebody, you want a particular outcome, and you feel like, now they're getting resistance, right, from a court, right, or there are lawsuits against it, right, or the person I've chosen, right, is running into tension with other professionals, military professionals, intelligence people, right, who keep saying things, right, that are out of line with what the elected leader wants, right? I can think of a number of examples from Trump's first term where they had a number of viewpoints on what Iran was doing, and then the military officers, intelligence officers, they were both military and intelligence officers, and also just the civilian intel people testifying before Congress, and they had to offer their independent professional assessment. And also there's a statute saying you can't lie to Congress, right? And so they provided their independent view of this, and it was not the same as the boss. And that resulted in a lot of tension and firings and what. So I understand why people have that have that sense of like, well, we voted, right? And now we're getting resistance, right? Or we're not getting this. And again, what I would say is that the system is designed in many respects to be a restraint on too much concentrated power, but it also offers paths for changing things, right? So for example, I'll give a very concrete example here, right? So President Trump issued an executive order, which said that people in the executive branch, right, shall look to him or to the attorney general with his delegated authority, right, for the executive branch's understanding of the law, right? And that is not completely outlandish because the president is the chief executive, but it runs up against longstanding norms about different agencies do interpretation in any event, right? So he's issued that, and that is running up against the professional obligation of a lot of lawyers serving in government, many of whom have been fired or resigned in dramatic and eloquent letters, right? Because the positions now that many of those lawyers are being asked to take in court, in their judgment, are unethical. They are frivolous legal arguments that cannot be sustained, or they are in one case in the Southern District of New York, trying to basically use the threat of prosecution to compel the mayor to cooperate with the president on policy matters. And this is just inconsistent with our ethics about how we understand the prosecutorial power, right? So that's where we are right now. But again, the system could be used to write different rules, right? Like Congress could pass a statute, right? And say, that, basically override legal ethics for lawyers who serve in the executive branch. They could do that. But that's not being done. And instead, it's just, again, one person saying this is how it is and running up against, legal ethics as they exist right now. So what I always come back to is, try to look at the design of the system and how that system can actually function. If people say like, I'm going to try to use the system that we have, right, that has been given to us by the framers, and not just trying to say like, well, I don't care about the details of democracy. I don't care about the details of law. I just want a result. I think that if that's the attitude, I think that the framers would want to sit down with us and say, no, actually, you should care about structure a lot.
Dakota, I wonder if you could discuss the unique challenges faced by military officers in an environment where the democratic operating system, as you said, resists autocratic software, particularly in the context of constitutional gray zones. As you have so powerfully written in your scholarship and here in our podcast, you've identified how lawyers have, of course, a special duty to uphold the Constitution. The military does as well, but it strikes me that the military is in a somewhat disadvantageous position when the constitutional dispute is a gray one. Lawyers, by our very nature, our job is to draw those conclusions for ourselves as part of our professional duty as an attorney, whereas military officers are, as long as they're not a JAG officer, they are not deeply versed in constitutional niceties. And indeed, they have drilled into them from day one that we have civilian control of the military. So what's the advice or guidance you would have for military officers in this incredibly challenging era that we live in today?
Well, the first thing I'd say is that I look forward to your thoughts on that, considering your own background in the military, in law, and intelligence. If I'm not mistaken, you check all three of the boxes. So honestly, I want to hear your thoughts. I guess just again, thinking about what I've been writing about this and thinking about this, it is a great dilemma, and it goes to the title of one of the kind of core works in the field of civil military relations. In the title of the book is The Soldier in the State. And it's this classic work by Samuel Huntington. I'm sure some of our listeners will have read that or looked at it. And it's, this dilemma of the holders of the sword, right? People who have training and arms, right, to practice high intensity violence, high intensity organized violence. I think that's one definition of the military, right? High intensity organized violence that has state authority. And they exist in the context of laws and civilians and structures, right, which are, in democracies are protective of liberty and purport to exercise authority over them, right? When it's plain, the rest of your civil society does not have armored divisions and it doesn't have the ability to resist that. And so, the dilemma that, this inevitable, I don't know if dilemma is the right word, but it's this just qualitative difference between the military with that high intensity violence capability, right, and the rest of governance and civil society that doesn't. And so many countries throughout history, right, have just their military dictatorships. That has been, in fact, the norm throughout human history, and we still see that in a lot of places. And so Huntington's answer is that the way that, the answer here is subordination. You subordinate the armed forces to the political authority, to the civil authority. And that's certainly imagined in the Constitution that makes the elected president the commander-in-chief of the federal armed forces. And you look at state constitutions as well, right? The state militia, now in its organized form as the National Guard, right? They're subordinate to the civil authority, to the governor, to the legislature, right? Congress has expansive authorities over the military. So that's the answer that we've had And it has gotten a bit more nuanced, and importantly, over the centuries, as Congress, and we see similar things at the state level, but especially at the federal level, where Congress has also using its expansive authorities over the military, and there are more individual powers given to Congress over the military than over anything else. And many of them are just completely expansive, as in like the courts and the president just lose if they try to challenge those. They're that expansive, right? So Congress has tried to protect the independent judgment of the armed forces by doing a number of things in terms of how Congress has structured the armed forces and then created statutory protection for especially senior military officers to provide their independent assessment of military matters, national security issues. Members of the military are also protected if they go to Congress and have concerns about something going on in the executive branch. And what Congress has been trying to do is to get at one of the other problems, which has gotten so much discussion lately, which is, so what if you have this military organization that is subordinate to civilian authority, but the leadership of the leadership of the executive branch, right, the president and the president's political appointees, right, that they are not thinking about using the military in a way that is necessarily protective of liberty, right? Or that's the concern, right? So what do you do in a situation like that? And the framers were enormously concerned about this. And there was so much discussion at the founding of the country about whether creation of this new office of president, who'd be the commander in chief, right, whether this would be a threat to liberty. And the anti-federalists would not sign up to the Constitution because of it. They thought this is going to be dictatorship, right? And so the framers built in a number of things. Again, a lot of these powers for Congress to structure the armed forces, raise it, govern it, write rules for it, fund it or not, right? That's all with Congress, right? And then Congress has used those powers, as I said, to write some of these protections in there. And so that worked well enough, but there are still gray areas, which you mentioned, and some difficulties. And so just for example, so one of these is that under the law, orders from the president and from the president's subordinates in the chain of command, like the Secretary of Defense, right, they are presumed to be lawful. And again, that reflects subordination of the profession of arms, right, to the civil authority, right, acting in accordance with legal authority from the Constitution and from statute, presumed legal. And I think that, I think just that makes a lot of sense, especially if you're, in some sort of military operations context, doing full legal review, de novo, as we would say in the law, de novo legal review, right, of every order that comes from the president, the Secretary of Defense, or below, right? There would not be opportunity to move with dispatch, right, to use a Hamiltonian term, right? So I think that makes sense. But we also have a really strong principle in our legal system and in our civilization more generally that unlawful orders cannot be followed. And so the way that that's been resolved in the doctrine is a presumption of legality, but if an order is clearly unlawful, manifestly unlawful, then military personnel cannot follow it. So the question is, how do they know? How do they know? And I think that that's a really, really urgent question. And I think if it was something like, you can think of like really obvious examples, right? Like, and I'm not ascribing this to anybody. I'm just saying, like, if you had a presidential order to, have a B-52 strike on the Supreme Court, I think that's manifestly unlawful, right? I have no concern that would ever be executed. But it gets more difficult once we get into some other constitutional processes and norms. And it also gets into, I think, difficult when the questions of law start to get a bit more complex than the just kind of like bright line stuff like I just described, right? Like, how should we understand the Insurrection Act? How should we understand the Posse Comitatus statute in the context of, court cases that interpret that and whatever? And it's just like the amount of complexity there is so great that the risk is that you could have an instruction from the civilian leadership, right? Indeed, pursuant to something like the executive order that President Trump issued, saying he's the final authority on the law, right? Just saying, like, on this question of law, there's a lot of complexity, or maybe not even saying those words, but just saying, like, our interpretation in the executive branch, is A, right? And then you could have a lot of people who are deeply knowledgeable about law, who would probably come along and say, well, no, I don't think that that's accurate, right? And maybe if that went to the courts would also say, no, I don't think that's accurate, right? But if it is sufficiently murky that it's not clearly unlawful, right? I think that the great risk in our system is that you can see the military executing orders, which again, like courts would probably say is unlawful. Most scholars and jurists and lawyers would say is unlawful, but there's just enough ambiguity there, or enough ambiguity maybe generated in the public space that it feels like, well, we just have to presume that that's lawful. And I think that that's a really, if you're somebody who has a lot of concern about this administration, I think that's a big worry. I think the question then of what to do about it, I think it would be either clarification of the standard by Congress, or it would be just a lot of public education about what the law is, with the hope that that kind of general public education, permeates into the ranks, right? To understand that this is how the law operates. But, Tony, I would love your thoughts on that as someone who's actually worn the uniform.
Yeah, Dakota, without doubt, I think this is a very difficult, complex question, one that I don't have an answer for myself yet, because of, as you said, it's the matters where the law is ambiguous, or where there is not a precedent, or where it's interpreting a complex statute like the Insurrection Act. As a lawyer and as a veteran, I'm not sure what the answer is. If you're an active duty service member and you're given an order and there are great time pressures, that's a really difficult position to be in. So I think my answer is unsatisfying. I don't know what the answer is.
And so, so does it sound right to you that, basically public education by people who are expert in the law, right, on these matters, trying to anticipate things that might come down the pike, right, and, that could be helpful?
Oh, I agree. Absolutely. I think it's the, in election law, we talk about democratic erosion. That really has become a focus, where it's not the dramatic overturning of democratic principles, but instead it's a slow eroding of the foundations of democratic norms. And I think that's the concern that I have with regard to the position that the military could potentially be in, that it wouldn't necessarily be, as you said, calling in an airstrike on the U.S. Supreme Court building, but something that would establish a precedent that over time we would end up seeing a creep, where an expansion that would be very damaging over the long haul. And indeed, you made reference to ancient Rome, Republican Rome, but of course, in the end, it ended up becoming imperial Rome, and it didn't happen overnight, as you know. It happened over really a number of generations, where there was a slow erosion of Republican principles, and ultimately a consolidation of power in one person's hands, Julius Caesar. And so I think that I still think we're very firmly in small R Republican America, but these long-term issues, I think, are the ones that are most troubling to me, because of this issue of what the short-term measure we take might make absolute sense right now, but what are the unintended consequences of it? I think that's what troubles me.
Yeah, and I would just add on that too, as a number of scholars have pointed out, we have, I think our default cultural understanding is when, you have a republic that collapses into authoritarianism, right? Or, basically the rule of law is lost, right? And you have an authoritarian government. What we mentally have in mind is like a sudden military coup, right? They're just like suddenly tanks in the streets one morning and the military clamps down, right? And yes, that's happened a few times. Chile, 1973, a number of other examples of that, right? However, what people who have studied this and study history tell us is that the most common way in which republics turn into authoritarian states is actually there's an election, and you have or many elections, right? And you have over time, as you say, right, a decay in constitutional culture and growing authoritarian trends and tolerance among people and institutions. And then at some point you get an elected government that just says, okay, we're going to do this. And it is a process, right, over, months or years, right, to turn that system into an autocracy. And that's what we've seen in Hungary, in Turkey, in Russia, in a whole number of places. And so I think that that's the concern, right? And so I think constitutional culture matters a lot as we think about that. And that's a matter for, people who are in these professions. It's a matter for, I think, especially for the voters in civil society, right? And try to think longer term than what your kind of near-term preference is, and have as much we as you can. We are one polity. We may disagree about things, even passionately. That's a feature. That's not a bug. And that we and maintaining that constitutional structure over the long run for your descendants, right? That's the most important thing. And it's not realizing some sort of near-term, thing which has been promised to you.
Yeah, that seems to be a real challenge. And at a point earlier today, you were observing how the framers of our constitutional operating system might react to certain of the current circumstances. And of course, they were steeped in an understanding of some of that Roman history and other historical examples, and knew full well that they were creating a process, and that the process was critical. Whereas today, I think it's too easy for many of the citizenry to think about just their short-term interests, and the ends are what matter, not the means by which we get there. So I really appreciate your invitation that we do what we can to help people understand that in the long term, we'll all be well served by remaining kind of allegiant to a process.
Yeah, and I tried to, in my courses, a number of them that I teach, we are, grappling, either directly or pretty clearly adjacently to these issues. And the approach that I take is to present students with an array of sources on these issues. Original sources, we have, pretty much all my classes, we read almost all of them. We read the text of the Constitution. We have Federalist Papers, excerpts, and then we have, what scholars have written since then, and informed journalists and whatnot, right? And just really try to get, a sense of some of these governance dilemmas that we have regard to, the military, the intelligence services, lawyering in the context of republic, lawmaking, legislation and regulation, and just really put some reflection on this in view of the structure we have, try to understand that structure and the thinking that animated the framers who, Steve, as you just mentioned, right? I mean, it is so much fun, I think, to read the Federalist Papers, because it is encountering people who were deeply steeped in history. And we're actively thinking about how can we make a new try at this idea of having popular sovereignty and sustaining the rule of law, right, amid national security threats. I mean, they just come out of the War for Independence, right, and living under British occupation, and the British Army having general warrants to search anywhere for anything. I mean, like, the Constitution was very importantly a national security document, right? But they wanted what they called the Empire of Liberty. And like, so how can we, so they reviewed history, like, how can we look at the lessons of history, right, and think about what we want, right, and craft something that's going to work better? Because their conclusion was basically republics and democracies had always failed. Why? But they still felt like, well, we don't want to live under, we don't want any more kings. We don't want authoritarianism. This is hostile to liberty, individual liberty, economic liberty. And their solution, as Hamilton and Madison wrote about, was the large republic. They said, like, well, nobody had ever tried a republic on a continental scale. And they thought size matters. That's the thing, is we're going to have a big enough republic that we will have, because you have a more expansive republic, right? You're going to have more regional viewpoints and more, religious minorities, right? Local economic interests, whatever it might be, right? And you're going to have so many of these like groupings and factions that they're going to balance each other out. And one will never become dominant. One faction will never become dominant, and or one individual who leads a passionate faction. And that favorable tension, which is then captured by the three branches of government and dividing Congress, right? And then having powerful states on a second level, right? And then a Bill of Rights for individual rights. I mean, like that structure, right, is going to protect liberty with that kind of constant favorable friction. That was their theory, continental scale. Well, of course, what did they not anticipate? National political parties. And very quickly, Madison, right, working with Jefferson, was creating the Democratic Republicans, right? And Hamilton was creating the Federalists. And by the late 1890s, it was as toxic as it is today, perhaps more. And people were enormously worried. Would the Constitution survive? Well, they had elections. They kept going with elections. They kept going with the rule of law, and it did. It did. So I actually look at that time, and that's the reaction when I read some of my student essays. Some of the essays from my students about this. They're really, I think that they, maybe just in their high school or college survey courses didn't fully kind of upload that, and they're really surprised, but I think they're also kind of reassured to see like how bad things got in the late 1890s and into the early 1800s, and yet we got out of that. So it's just fascinating to hear their thoughts on like how much can we map, how do we apply those structures from the founding era, right, to where we are, with changes like creation of like these professions, right, in the administrative state.
Well, as we often say, more specifically in the election law context, for this system to perpetuate itself, people have to be willing and prepared to lose.
Yeah.
That's a real fundamental here. We're really sort of about at time, though. I'd like to give everybody a chance to offer final thoughts or ask one more question before we wrap for today.
I would just add on an optimistic note, consistent with what Dakota just said, our national capital is named after not only our first president, but also the commander of the American Army during the Revolutionary War, George Washington, who famously in 1783 single-handedly put down a budding military conspiracy against the Congress. Washington was committed to democratic rule and a civilian government that was subject to the rule of law. So I think the spirit of Washington is still alive in this country. And as Dakota said, I do think that a focus on public education about our history is critically important to secure our future.
Well, on that note, we'll wrap this edition of Law and Democracy with extra thanks to Dakota Rudesill for being with us. Dakota, thank you for spending this hour chatting with us. It's been a fascinating conversation, and we look forward to more to come. So thank you, everyone, and take care.